Good afternoon and welcome to Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is episode 6, State of Missouri versus Marcellus Williams, part 2. We'll look at Williams' federal post-conviction claims, which is where we left off in part 1, and his subsequent state and federal claims, which led to a stay of his execution in August of 2017. We'll finish with the executive order issued by Governor Michael L. Parsons in 2023 that rescinded the 2017 executive order of his predecessor. This may not sound like a lot, but it is, I promise. And good afternoon, Kyle.
Good afternoon, Lisa. How are you?
Pretty good. Just there is a lot more to this case than I thought. I was very surprised when I was working on part 2 notes, and
And
I
realize
just
quickly this is
realized,
going to be a part three.
I was like, this is not going to work. So I cut it and decided to do a part 3. And ironically, everything in part 3 is essentially going to be 2024. But they
Well,
had
you know,
such
I mean,
state claims, federal claims, it was crazy.
a total side note, I feel like our legal system in general is extremely complicated. And I don't know if this is a fair statement, but I was listening to a podcast about like a case in the UK. And it's like the guy was convicted and executed within like, I don't know, less than a year. Like, it just seems like we have a
Well,
system very much built upon
now
monetizing attorneys. It's
the
amazing how complicated these are.
you you can't really compare the UK, and you're speaking, I mean, executions were outlawed in the UK in like 1950 or 60s. So, that doesn't really happen. But yeah, they don't their system does not have the post-conviction review. Once you're
Right,
convicted and your conviction is upheld, that's it for you.
right.
Um, but they also have essentially, you as a defendant would bear a burden of proof. It's not solely on the Crown to prove your guilt.
Right.
So it's a little bit different. And, like
And they have the great wig.
if you don't tell police about a defense and then you try to use that at trial, that actually counts against you. Because that's one of the warnings that are given in British. If you try to rely on a defense that you don't tell us about, that can be used against you. So,
Right.
um, but in the 30s and 40s in the United States, it happened very quickly, within months,
Yep.
or within 3 or 4 months, or no more than 12. But there wasn't as much. The procedures did not allow for the post conviction that goes on today, or that is available today. So, but yeah, it's a lot, and it can be. Um, I mean, Rodney Reed's filed yet another writ with the state court in Texas, where he's recycling a lot of the relationship witnesses and presenting new relationship witnesses who are now coming forward. I mean, this month is the 30th anniversary of Stacy's murder. That'll be on the 23rd. So, 30 years, and he's still trying to prove a relationship to explain away his DNA on her body and on her clothing. So it is crazy, but that's due process. So unfortunately, we have to let it play out. Um, all right, so let's go ahead and get back to part 2. Of course, the victim is Felicia Ann Lisha Gale Pecos. She was born February 6, 1956 in Rockford, Winnebago County, Illinois. Her parents were George Wally Gale and Victoria Bunky Bunk Gale, who died in 2021. Felicia was the second of 8 children. Her brother William, and then she was followed, it was William, Felicia, then Sanford, Andrew, Sydney, who was called Beth, Samuel, who passed in 2004, was number 6, Emily was number 7, and Christopher was number 8. She attended Guilford High School and graduated in 1974. She also spoke at her commencement, and she graduated from the University of Illinois in 1981 with a degree in journalism. I also found additional employers in a couple of articles that I found. She worked for the Illinois State Journal in Springfield, Illinois. That may have been like an internship or a job while she was in college. She worked at the Hammond Times in Hammond, Indiana, and then she went to St. Louis Post Dispatch and had the police beat from 1981 to 1992. She became disillusioned or burnt out and left in 1992 and became a mentor and tutor for disadvantaged students in St. Louis. She, of course, had settled in St. Louis with her husband, Dr. Daniel Pekas, who was the head of interventional radiology at a hospital in St. Louis. He is, I believe, still there today. And they were married September 21st, 1979. Licia's cause of death were multiple stab wounds. Then we have her, the perpetrator in this case is Marcellus Scott Williams Sr. He also converted to Islam during his time in prison and was known as Khalifa Ibn Rayford Daniels Abdi
Yeah, if there's a sure
Kidder.
sign that you're guilty, it's that you converted to Islam.
So, um,
Like you might as
he
well
was
just
born.
confess.
He was born December 30th, 1968, in South Bend, St. Joseph County, Indiana. His father was Rayford Daniels. I found that in I found another article, and that did identify his father as Rayford Daniels. His mother was Ella Louise Williams. He has 3 brothers. I don't know their names, and I didn't find where he was in that family. He dropped out of high school in the 10th grade during the second semester. He has a son, Marcellus Scott Williams Jr. He had been diagnosed with oppositional defiant disorder, depression, and post traumatic stress disorder. Um, and I think there was also an element of psychopathy or sociopathy because of his criminal background and history. Of course, he had 7 arrests as a juvenile and had been remanded to the Division of Youth Services. He had 16 adult convictions for crimes
I think as
including
I said
second
last
degree.
week, I think I made the joke last week. I'm surprised you can actually just get diagnosed as an asshole.
Yeah. Um, so, yeah, well, yeah, that's usually oppositional defiant is usually something you see in children. And I don't,
Yeah.
like I said, and I think we talked about this. Um, Sometimes I think some of these things are being used as a crutch.
No,
You
absolutely. I
see,
mean, if you're just an asshole criminal sociopath,
yeah,
if you can attach some kind of, diagnosis to it, we're supposed to feel like it's not your fault. I mean, the guy's just an asshole and a jerk and, you know,
yeah, yeah,
just a terror on the community like so many. I mean, we see it every day, but
and
how many
has no,
disorders you can attach to him doesn't change the fact that, you know, he's a
yeah,
son of a bitch.
has no moral compass.
Yep.
Anyway, so his 16 adult convictions included second-degree burglary, stealing over $150, and second-degree assault in 1988, second-degree burglary and stealing over $150, 2 counts in 1991 each. And then first-degree robbery, armed criminal action, unlawful use of a weapon, and first-degree robbery, armed criminal action, stealing a motor vehicle, and false imprisonment, all in 2000. And these were for crimes that occurred in 1998, and everyone will be hopefully pleased to know that I've solved the mystery of the timing for the Burger King and donut shops, which we'll get into in a minute. He served 7 years from 1990 to 1997 in the Missouri Department of Corrections. His disciplinary history included 100 infractions, including verbal and physical altercations with inmates and corrections officers. And he threatened to kill a corrections officer in 1999 at the St. Louis City Workhouse while being held, awaiting trial for charges in St. Louis. And I believe that this was also in connection with an attempted escape. And his victim was Felicia Ann Lisha Gale Pecos, who was 42. Just a quick summary. The crime occurred on August 11, 1998. On that morning, Lisha finished her daily 2-mile run and, after a chat with her neighbors, returned to the home she shared with Daniel Pecos, her husband, to shower and change into her favorite long purple t-shirt. Williams left his grandfather's Buick LeSabre at a bus stop in St. Louis and rode the bus to University City, an upscale St. Louis neighborhood. He chose Lisha and Daniel's house because a tree partially obstructed the front door of the home. When no one answered Williams' knock at the front door, he broke the glass in the door, reached inside to unlock the door, and entered the house. He heard water running on the second floor while he was up there searching for valuables. He could have grabbed valuables and gotten out of the house, but he didn't. Instead, he went downstairs to the kitchen, armed himself with a butcher knife, and laid in wait for his victim. Lisha finished her shower and put on her t-shirt, then went downstairs. And there are some accounts that say she was calling out because she thought someone might be in the house. When she encountered Williams, he attacked her with the knife. Lisha was stabbed 43 times, 16 of which were fatal wounds, and had wounds in her head, back, thigh, and neck. She also had defensive wounds on her hands and arms, including a deep cut in her elbow. When Williams was done, he left the butcher knife in her neck. After he killed Lisha, he grabbed a jacket to cover his bloody shirt, stole Lisha's purse and her husband's laptop and case, and returned to the bus stop, riding the bus back to his grandfather's car. When he picked up his girlfriend, Laura Asaro, she saw Williams' bloody shirt and scratches on his neck after he removed the jacket, which he was wearing in August in the heat. Williams told her he'd been in a fight. Later that day, she watched as Williams put his bloody clothes in his backpack and threw it down a sewer drain. Asaro also saw a laptop computer in the car. A day or two after the murder, Williams sold the laptop to Glenn Roberts. Shortly after that, Asaro went to retrieve clothes from the trunk, only to be pushed away by Williams, who didn't want her looking in the trunk. That didn't work, and she found Lisha's purse. When she looked inside, she found Lisha's Missouri ID and a black coin purse. Asaro demanded to know why Williams had another woman's purse. It was then that Williams confessed to Asaro, telling her he'd broken into the house, found the butcher knife, and waited for Lisha to get out of the shower. He then told Asaro that he'd stabbed Lisha in the arm, then covered her mouth, stabbing her in the neck and twisting the knife. After confessing, Williams grabbed Asaro around the throat and threatened to kill her, her children, and her mother if she told anyone about his confession. And these were details that had not been released to the public as far as the stab wounds and how many stab wounds and where they were,
Right.
including the knife being left in the neck. On August 31st, Williams
Man, he
was
seems like
arrested.
a great guy.
Oh, yeah. On August 31st, Williams was arrested after a robbery at a donut shop. He was incarcerated at St. Louis City Workhouse and facing charges for that crime. In April of 1999, Henry Cole was assigned to a Williams' room. One evening in May, there was a news report about Lisha's murder that included information about a reward of $10,000 being offered by her family for information leading to the arrest and conviction of her killer. It was shortly after that report aired that Williams admitted that he'd committed the murder. Over the next several weeks, Cole and Williams had several conversations about the murder, and Williams confessed. As he'd done with Asaro, Williams provided details about how he broke into the house and his attack on Lisha, which included information that had never been released to the public. After his release, Cole immediately went to the University City Police, where he was interviewed on June 4th, 1999. He reported Williams' statements and directed police to Asaro, who had not yet come forward. Asaro was interviewed on November 17th, 1999 by University City Police, and it was then that she told them about Williams's confessions, providing information that could have only been known by the killer. The following day, police searched Williams' grandfather's Buick LeSabre and found a St. Louis Post-Dispatch ruler and calculator that had belonged to Lisha. They were also able to track down the Daniel's laptop computer that had been sold to Roberts and identified it as the one stolen from Lisha's home after her murder. Police also secured Roberts' cooperation. Now, there was mention, and we'll probably get into it. Williams apparently told Roberts that he got the computer from Asaro. And that just shows me, and this is just my speculation, but that just shows me that he was already planning to try to pin the murder on her.
Well, I mean,
Or
he
it was
seems like such a
simply,
nice, honest man. I'm sure he was framed by the police. I'm sure it was racism.
so yeah. Um, and this is, again, her murder goes unsolved until basically they don't even call it solved until they talk to Laura Asaro in November, because that's when they officially the wheels began turning to charge him. So this was not a rush to judgment by any stretch of the imagination. Now, I wanted to go over a couple of little miscellaneous things that we may have gone over in part one, but also some new information, because I was able to solve the mystery of the Burger King and the donut shop robberies. First of all, we have the murder of Deborah McClain, who was stabbed in her home in Pagedale, Missouri on July 18th, 1998. Pagedale is another St. Louis suburb. On July 25th, 1998 is when Williams robbed the Burger King and apparently held several employees hostage at the Burger King. He was charged with robbery in the first degree, armed criminal action, kidnapping, 3 counts of kidnapping, and stealing a motor vehicle. And then on August 11th, 1998, he commits the murder of Lisha. So he's got burglary in the first degree, murder in the first degree, armed criminal action by 2 counts, and robbery in the first degree. And just to clear something up, burglary is the act of going into a residence that or a place that is not yours. You don't have to take anything. Once you cross the threshold with the intent of taking something, it's a burglary. And you may not even have to have the intent of taking something. You may just going in, it's not yours. It can also be trespassing, but
Right.
robbery
Isn't there
is
kind of like a legal nuance? Like if
yeah,
no one's there, it's a burglary, but if somebody is there, it's a robbery.
correct. And basically your act of entering with the intent to take something is burglary, but once somebody's there, it's robbery. It becomes robbery when you're taking from a person or in the presence of a person. So that is and it's a distinction, kind of like the distinctions between assault and battery. So and they can vary from state to state as well, because I think like battery is unwanted touching, assault is an injury, has to include an injury. All right, so there is a supplemental report issued on August 26, 1998, and this is after a meeting held at the St. Louis County Medical Examiner's Office among University City detectives, Dr. Mary Case, the medical examiner, and St. Louis County PD investigators to discuss possible connection between Lish's murder and Deborah McClain's murder. And there are some similarities. The victims were similar in age. McClain was 40, Lisha was 42. They had a similar build. They were both women who were petite with large breasts and long brown hair. And that is exactly how they're described in that report. Injuries, they each had stab wounds on the right side of the neck and in the front and back um, upper torso areas. Similarity of the crime scenes, there was very little disturbed. Knives were from their own kitchens. Their purses were missing, and a knife was left either in the victim's right side of the head or neck. The crime scenes were close in proximity, and they each had defensive wounds, although Lisha had more defensive injuries than McClain. And then August 31st, 1998 is when Williams robbed the donut shop and was caught. And he committed robbery, armed criminal action, and unlawful use of a weapon because he's a convicted felon. Okay, so I want to go through a quick procedural summary, and I'm going to try and keep it quick because I don't want to end up having to bail early on this one because we'll never get done if I keep doing that. Bad Lisa. He was indicted on January 6, 2000 for burglary in the first degree, murder in the first degree, armed criminal action, robbery in the first degree, and armed criminal action. He was arraigned January 18, 2000 and pled not guilty, although nothing official says that. He, before his trial began, the judge made findings of fact, finding him to be a persistent offender on June 4th, 2001. His jury selection took place between June 4th, 2001 and June 8th, 2001. His trial began on June 8th. It was 14 trial days, and then the penalty phase commenced on June 16th to June 19th. The verdict on June 15th was guilty of all charges. The judgment was entered on June 15th, finding him guilty. They went to the penalty phase, and on June 19th, the jury recommended death after also finding 10 out of 10 aggravating circumstances. On August 27, 2001, Williams was sentenced, and he got 30 years on count 1 and count 3 and count 5. Those are the burglary and, I believe, armed criminal action charges. He got death on count 2, which is the murder charge, and life on count 4, which was the first degree robbery charge. And I believe those were going to be served consecutively to the one of the other robbery charges. In the 2 robberies, he was sentenced concurrent, so they would all run at the same time. And this one was going to be consecutive to one or both of those. On direct appeal, I'm not going to go over all the issues raised because we kind of went over that in pretty good detail. But his conviction and sentence were affirmed on January 14, 2003. But on January 24, 2003, his execution, which had been Missouri, like automatically sets an execution date. It was stayed until further order of the court on March 24, 2003, because he had applied for a petition to the U.S. Supreme Court. That was denied on June 23rd, 2003. He filed a state post-conviction, which I don't have the data filing and everything. He did get a post-conviction evidentiary hearing. His matter was taken under submission. That was March 12th, 2004. 2 months later, on May 14, 2004, the court issued its findings of fact, conclusions of law, order, judgment, and decree, and denied post-conviction relief and Williams's motion for reconsideration. He filed a post-conviction appeal. Again, I'm not going to go through the issues, and we will see most of them again in his federal habeas claims anyway. That there was oral argument on that case on April 14, 2005, and then on June 21st, 2005, the judgment of the post-conviction motion court was affirmed. And that's where we kind of left off last time. So now we're in his initial federal habeas claim. That was before the United States District Court for the Eastern District of Missouri in St. Louis. The docket number was 4:05-CV 01474 RWS. And those initials, when you see those initials in federal cases, that stands for the judge. And then if there's a second set of initials, that's the judge. And that was before the Honorable Judge Rodney W. Sipple. Attorneys for Williams were Kent E. Gibson, Lawrence E. Comp, Lori Leon, and William C. Odell. Counsel for the state of Missouri were Mickey J. Spillane, or Michael J. Spillane. I'm sorry, Mickey Spillane was a 1950s true detective novel author. So every time I see his name, I want to call him Mickey. He's an assistant attorney general, and Jeremiah W. Nixon, also an assistant attorney general. And just to, you're not on the stage, Kyle, and your camera's on. Oh, and now he just disconnected. Oh,
And
there he is.
then,
He's back. Yeah,
okay,
I'm so sorry.
No problem.
I just caught a flashing light, and I looked down, and your camera was on.
It's so weird that it defaults to camera on. It seemed like it would default to camera off.
Yeah.
But
And
I got booted a bit ago, but thought I was back.
Oh, okay. Well, you were back, but you weren't on the stage. And I'm going to turn my phone, my sound on my phone. So if you get booted again, text me.
All right, sounds good.
And I'll know by your text notice that there's a problem, because I'm looking at my notes and not looking at the screen. So the first thing is a motion to appoint counsel in a habeas corpus petition action in a death penalty case, which was filed on September 12, 2005. An order was entered on September 16th, granting the motion for leave to proceed in forma pauperis, and granting the motion to appoint Gibson and Odell as counsel for Williams. The petition for writ of habeas corpus was filed on August 29, 2006. So it wasn't filed immediately. There was almost a 1-year delay, like 11 months. Claim number 1, the prosecution violated petitioner's 6th, 8th, and 14th Amendment rights in failing to disclose material evidence that could have been utilized to impeach the credibility of Cole and Asaro, failure to disclose mental health records and related impeachment information regarding Cole and Asaro, the state's deliberate concealment of Cole and Asaro's whereabouts, the prosecution's attempt to manufacture additional jailhouse information, evidence against petitioner. Those were cited as 3 of the things. Credibility of Asaro. Claim 4, petition's conviction and sentence of death were secured in violation of the 8th and 14th Amendments because he was convicted on the basis of perjured testimony of Cole and Asaro, and because he's actually innocent of the murder of Felicia Gale. Claim 5, Williams and Black veneer members Gooden, Singleton, and Fortson were denied equal protection of the law when the prosecution struck them from the jury on the basis of their race in violation of Batson versus Kentucky. Veneer person 64, Gooden, steps 1, they kind of go through for Gooden, then Singleton, then Fortson, who are veneer persons 64, 65, and 72. They kind of go through um, making what their Batson claim is. And then also he argues the recent McFadden decision and other evidence established that St. Louis County prosecutors have a longstanding practice of excluding Black citizens from jury service. Claim number 6, Williams was denied his 6th and 14th Amendment rights to effective assistance of counsel because his attorney failed to conduct an adequate investigation and present available evidence regarding his background and social and medical history, which would have provided compelling mitigating evidence at the sentencing phase of trial. Had this evidence been discovered and presented, there is a reasonable probability that the outcome would have been different in the penalty phase. Petitioner's counsel on direct appeal was ineffective in failing to brief a meritorious due process claim arising from the trial court's denial of petitioner's continuance requests. Claim 8, Williams' 6th and 14th Amendment rights were violated because his trial counsel labored under a conflict of interest and the trial court failed to address the issue. Claim number 9, petitioner's 6th and 14th Amendment rights were violated by the trial court's restriction of petitioner's cross-examination of prosecution witness Roberts. Claim number 10, petitioner's appellate counsel was constitutionally ineffective for failing to brief the issue of the trial court's improper exclusion of the mitigating evidence from Dr. Mark Cunningham regarding the adverse impact that petitioner's execution would have upon his family and children. Claim number 11, petitioner's 8th and 14th Amendment rights were violated by the prosecution's improper closing arguments during the penalty phase of trial. Claim number 12, trial counsel was ineffective in failing to request a limiting instruction regarding petitioner's escape attempt. Claim number 13, petitioner's death sentence was imposed in violation of the 8th and 14th Amendments because 3 of the 10 aggravating circumstances submitted by the state were unconstitutionally duplicative. Williams also filed a motion for discovery to conduct further DNA testing, a motion to authorize discovery, seeking records regarding Cole Asaro and the murder of Deborah McLean. A motion for an evidentiary hearing was also filed on October 12, 2006. On December 7, 2006, the state filed its response to the court's order to show cause why the writ of habeas corpus should not be granted. And I missed that one, sorry. Ground 1, regarding the alleged Brady violations. Williams's claim is essentially that the state was responsible for going on a fishing expedition into the mental health records of its witnesses, despite their rights to privacy and confidentiality, and presumably, if necessary, litigating against its own witnesses to discover potential information to turn over to the defense. Williams further appears to argue that he is entitled to relief, although he never explained to the state courts specifically what the relevant information is or how it would have made it more probable than not that he would have been acquitted. Cole and Asaro psychiatrists were not working on the government's behalf in this case, and the prosecutor apparently had no knowledge of what was in their records. He had no duty under any clearly established United States Supreme Court precedent to discover this information, this material. Regarding the allegedly manufactured evidence, they argued that there is no reasonable probability that testimony about witnesses that did not testify would have created a reasonable probability the outcome of trial would have been different. Regarding the whereabouts of Cole and Asaro, the post-conviction review motion court found that counsel deposed both Cole and Asaro thoroughly and extensively several months before trial, that Cole's deposition in New York City lasted 2 days, and that Cole was cross-examined extensively in St. Louis at a deposition 2 days prior to trial. The court found that Asaro was deposed several months prior to trial, and that both Cole and Asaro were available to trial counsel prior to trial. Regarding ground two, the response was that the Missouri Supreme Court rejected the claim, finding that the evidence counsel was allegedly ineffective for failing to investigate, discover, and present was, under Missouri law, inadmissible impeachment evidence based on prior alleged misconduct. Regarding impeachment of Asaro, the impeachment evidence was essentially cumulative of the effective cross-examination and impeachment of trial, and there was no evidence or allegation that Asaro was at the crime scene. There was no reasonable probability the outcome of trial would have changed and with additional impeachment. Regarding ground four, the response was that Williams does not assert any new evidence that was not known or knowable through due diligence in time to present his claims at trial. Therefore, he cannot make out a gateway innocence claim. And then they cite Meadow versus DeLeo. The test for newly discovered evidence is whether the evidence could have been discovered earlier in the exercise of due diligence. Williams offers nothing new, but rather places a pro-defense spin on information available and largely presented at trial. Further, it cannot be said that it is more likely than not that no reasonable juror would convict in light of the evidence presented at trial, even if Williams' current spin on events is considered new evidence in evaluating a gateway innocence claim. Williams had the burden to present new evidence supporting his actual innocence claim with his petition. Williams may not have a hearing to seek to discover and present evidence that he only alleges exists. Further, Williams' perjured testimony claim is defaulted as he prudently did not present it to the state courts, despite having essentially the same information to build the claim he now has. This claim is also without merit. And then, citing Murray again, that the alleged contradictions in testimony are material for cross-examination and may cause the jury to disbelieve the testimony, but do not prove perjury. Williams cross-examined and impeached the witnesses. The jury believed them. Williams apparently does not like the result, but that does not prove perjury or knowing reliance on perjury by the prosecution. Ground five, the alleged Batson violations. The prosecutor in the case of these strikes was faced with what he viewed as an outlandishly dressed person working in a job he viewed as generally indicating liberality, who gave ambiguous answers on the death penalty, a person convicted for dishonesty, whom the prosecutor was not certain was qualified to sit as a juror under Missouri law, and a man who had become physically violent when he viewed himself as verbally provoked, and who the prosecutor perceived as insulted by another veneer person or other veneer persons laughing at him. The choice of exercising peremptory challenge on these jurors would seem to have been prudent, and finding that the prosecutor did not have a racial animus in exercising these strikes is supported by the record. Ground six, ineffective assistance of counsel for failure to investigate and present mitigating evidence. Williams is in reality arguing that there is one and only one way to try a capital penalty phase. One must always present a social history portraying a murder as a product of social factors beyond his control, even if this would undermine a viable defense that there is doubt whether he committed the crime and that he is not a terrible person. This is not law, and Missouri Supreme Court reasonably applied Strickland versus Washington in rejecting the claim. Its decision should be left undisturbed under 28 U.S.C. 2254D. And then regarding the continuance, the response, the Missouri Supreme Court, which is the same court that would have heard the denial of a continuance claim on direct appeal, rejected the ineffective assistance of direct appeal counsel claim, finding that the trial court did not abuse its discretion in denying the continuance. It appears direct appeal counsel knew her audience and declined to present a claim that would have lost if presented. The decision of the Missouri Supreme Court rejecting the ineffectiveness claim is consistent with a reasonable application of clearly established United States Supreme Court precedent and should be left undisturbed under 28 U.S.C. 2254D, as counsel acted reasonably and there is no reasonable probability the appeal would have come out differently had counsel briefed the claim. Regarding ground 8, the conflict of interest claim, the response was that what Williams is alleging does not appear to be a true conflict of interest claim at all, but rather an assertion and is an assertion of the claim of failure to investigate and present impeachment evidence concerning witness Cole that is similar to the one raised in ground 2. The post-conviction review motion court rejected the claim that counsel failed to interview Cole's family members who would have testified that Cole was a liar and motivated to testify by the $10,000 reward. The motion court found that the alleged testimony would not have been admissible and that Williams did not allege the family members would have provided admissible testimony about Cole's reputation in the community for truthfulness. The motion court also found that trial counsel attacked the credibility of Henry Cole in practically every way possible, using his drug usage, felony convictions, interest in the $10,000 reward, inconsistencies in testimony, and his viewing of television and newspaper articles about the murder. The Missouri Supreme Court affirmed this decision in Williams versus State. Ground 9, the limited cross-examination of Roberts. The Missouri Supreme Court rejected the argument, finding that Roberts testified to the sale of the computer and the state did not introduce any confessions or statements Williams made to Roberts during the sale. The Missouri Supreme Court found that Roberts' testimony as to what Williams told him during the sale would be inadmissible hearsay, and the trial court acted properly in excluding it. Williams cites no United States Supreme Court case that stands for the proposition that a trial is made fundamentally unfair if a defendant is not allowed to introduce self-serving hearsay through a third party in order to avoid testifying himself while still placing his version of the facts into evidence. Williams argues that the hearsay should come in based on the rule of completeness, which allows an entire statement by a defendant to come in if parts of it are introduced. But no evidence of a statement by Williams to Roberts was admitted. Undeterred, Williams argues that the rule of completeness is being applied mechanicalistically in an unconstitutional manner because the Missouri Supreme Court is not using the rule of completeness to admit hearsay, although no statement is in evidence to complete. Williams' argument is unreasonable. What Williams is really doing is making Chambers versus Mississippi argument for an exception to the rule against hearsay for exculpatory evidence which with particularized indicia of reliability. Of course, the hearsay Williams wishes were admitted lacks the indicia of reliability present in Chambers, rather than being a declaration against penal interest made under circumstances indicating reliability. The hearsay in this case was self-serving and made under circumstances indicating the opposite of reliability. Ground 10, the Missouri Supreme Court found this claim to be without legal merit. The Missouri Supreme Court pointed that it had previously found such evidence to be inadmissible, as had every court that had considered the issue except one. This claim was properly winnowed from the 10 issues ultimately raised on direct appeal. Counsel acted reasonably in not briefing in 2002 a claim that had been found to be meritless in State versus Smith. Further, there is no reasonable probability the outcome of the case would have been different had the claim been briefed. Ground 11, the prosecutor's improper closing argument. The response in the state appellate brief, Williams made the arguments that the trial court erred in not sua sponte intervening in response to a reference to Williams choking state's witness Asaro, and that the trial court improperly denied objections to comparing the trial with Williams' murder of the victim. Williams does not seem to be making the same argument he raised in state court. He now argues the prosecutor ignored the state court's admonishment not to comment on Williams' right to trial or to compare the worth of the life of Williams with that of the victim. Williams must present the same factual and legal theory he presented in state court. He is not doing so. He has shifted from the claims of trial court error rejected by the Missouri Supreme Court to claims of prosecutorial misconduct concerning the alleged comment on the right to trial, and has substituted a complaint about the about comparing the worth of the victim's life with that of Williams for the complaint raised in state court about argument concerning the choking of Asaro. The claims actually presented in state court are without merit for the reasons set out by the Missouri Supreme Court. These claims have now apparently been abandoned by Williams. Williams' current claims are barred from review as those claims were not presented to the Missouri Supreme Court. The current claims are also without legal merit. The argument Williams complains about concerning Williams being the judge, jury, and executioner was a proper response to Williams' plea for mercy, not a criticism of Williams for exercising his right to trial. Whew. The argument concerning protecting society was a proper argument for general deterrence. And then finally, they went on to say the argument Williams complains about is not even error and does not come close to being the kind of egregious impropriety necessary for a due process clause violation. Ground 12, the failure to request limiting instruction regarding escape attempt. The response was the post-conviction review court found that giving the instruction would have highlighted the escape attempt and that there's no reason to conclude that the jury used their knowledge of the escape as propensity or character evidence, as opposed to evidence of consciousness of guilt, the reason for which the evidence was properly admitted. The court concluded that no prejudice resulted from the lack of the instruction. There is no question that under Missouri law, the escape was admissible to show consciousness of guilt. The conclusion of the Missouri courts that no Strickland prejudice resulted from not giving an instruction that the escape could be used to draw conclusion consciousness of guilt, but not propensity, is reasonable and should be left undisturbed under 28 U.S.C. 2254D. As the benefit of such an instruction would be marginal at best. And then ground 13, the aggravating circumstances, the Missouri Supreme Court rejected this claim. Williams admits that the precedent of this court rejects the same claim. The Missouri Supreme Court cannot have unreasonably applied United States Supreme Court precedent, as this court has pointed out that the United States has never before held that aggravating factors could be so duplicative as to render them constitutionally invalid. And then they also responded to the request for discovery and evidentiary hearings. And basically, what Williams is trying to say is that the prosecutor should have gotten all kinds of records from third parties about Cole and Asaro and then provided that to Williams. That's his argument. And that's not how it works. That's not how Brady works.
All right.
Brady doesn't require the prosecutor to do the defense's investigation. And I think we talked about this before in the way that the state courts handled the claim, is that, the defense could have gone and filed subpoenas and gotten subpoenas for these records if they wanted them. So, and I think they had enough information to question Cole and Asaro each about their drug use, their criminal histories, their, incarcerations, their everything. So, as to discovery, the response was that the vast majority of what Williams requests appears to have nothing to do with anything that could conceivably fit into that definition. It is not relevant to the Brady claims. If something was not in the possession of state officials working on the case, it was not Brady material. Further, this material appears to have little or nothing to do with the impeachment evidence. Counsel is actually accused in grounds 2 and 3 of being ineffective for not presenting. This request seems to have no purpose relevant to the real issues in the case. Cole and Asaro presumably have a right to privacy and not to have all aspects of their lives rummaged through as punishment for having testified in a capital case. There's no reason to believe that federal agencies, agencies of various states, and various private institutions named will turn over the materials Williams wants without months or years of litigation. Williams appears to be attempting to bog the case down in litigation about matters that have no relevance to the disposition of the case. There is no good cause of the discovery he requests concerning Asara and Cole, and the request should be denied. Similarly, the requested information concerning the murder of Deborah McClain has nothing to do with any real issue in the case. Williams, who was found guilty beyond a reasonable doubt and who has never provided a plausible explanation of why he had the murder victim's computer or why her purse identification, ruler, and calculator were in the trunk of the car he drives, offers nothing but speculation that a phantom serial killer may have taken the items. As to the evidentiary hearing, they basically just argued that he was barred from having an evidentiary hearing because, in federal court, you have to develop the state court record. You don't get a hearing. And because his claims had no merit, they can be determined from the record. They don't need hearing. On March 30th, 2007, the court issued a memorandum in order basically denying the DNA testing request, finding no good cause for discovery. It held that the biological trace evidence has been tested. This is not a case in which the biological trace evidence has not been tested and, if tested, could exculpate petitioner. The record showed that the biological trace evidence did not match the DNA of petitioner, the victim, or the victim's husband. This fact was presented to the jury. As to the motion for discovery, the court noted that defense counsel had pretrial access to Cole and Asaro's statements and that they were extensively cross-examined by trial counsel about their personal background, criminal past, medical histories, knowledge of the reward, and possible motives for testifying at trial. Ample reasons to question their credibility were before the jury. Additional criminal and mental health treatment records for these witnesses would be cumulative for purposes of impeachment. Petitioner has not articulated any specific basis for connecting the Pagedale murder to the present case. Any connection between the two crimes is merely speculative. He also said the allegations before the court do not show reason to believe that petitioner may, if the facts are fully developed, be able to demonstrate that he is entitled to relief. As a result, the motions for discovery and additional DNA testing will be denied. He did find that the petitioner was diligent in raising the issues and seeking to develop the facts in state courts. However, he did not find that there are any material facts in dispute with respect to the habeas claims or that material facts were not adequately developed in a state court hearing. The judge said, I note that there was an evidentiary hearing in state court and the facts were developed on the issue of trial counsel's advice to petitioner about testifying during the penalty phase. I believe petitioner's habeas claims can be resolved by careful review of the record without an evidentiary hearing. As a result, the motion for evidentiary hearing will be denied. And then Williams filed a motion for reconsideration on April 9th, 2007. That was the court entered an order on April 23rd, 2007, granting leave for Williams to file a reply brief concerning his discovery motions and requests for evidentiary hearing, and that the reply brief shall be filed as an independent document separate from Williams' traverse, which is basically you can file that to get an evidentiary hearing or to try to get an evidentiary hearing. The reply brief was filed on May 22nd, 2007. And then he filed a memorandum in support. Reply memorandum in support of request for further DNA testing. And I'm not going to go through the arguments he made. The state responded on May 24th. Williams filed a motion to strike respondent's response. on the same date. And on July 12th, 2007, the court issued a second order and said, at this point, the issue before the court is discovery. The merits of the petition are yet to be decided. I will deny Williams's motion for reconsideration of my order denying the request for additional discovery and for an evidentiary hearing. I find that Williams' discovery requests do not meet the good cause standard applicable in habeas proceedings. The issues raised in Williams' motion for reconsideration do not convince me that my previous ruling was an error. Williams' traverse was originally required to be filed 45 days after respondent filed his response to the show cause order. Williams' traverse should have been filed by January 22nd, 2007. Williams has requested and received 2 extensions of time to file his traverse. Williams' present motion seeking an extension of time to file his traverse is based on a presumption that further discovery will be allowed in this case. The extensions of time have already extended the filing of Williams' traverse for more than 6 months. Because there will not be any further discovery in this matter, Williams shall file his traverse by August 17, 2007. And, you know, in a civil case, in civil litigation, you would just have committed malpractice if you didn't file your stuff on time without filing an extension of time. You know,
Yeah, I mean, they just let them.
so the criminal cases do get a lot of leeway. I have very rarely seen a court reject a late filing of a petition or a late filing of a reply or a late filing of an opposition. And that's leeway that, a lot of civil law litigants don't get.
Don't get it right.
Williams did file a traverse on August 31st, 2007, and basically he was more or less just reiterating all of his claims. And this is to show that he is entitled to, that he's entitled to hearing. So I'm not going to go into those again because they're identical. And then he filed a supplement to the traverse on January 14th, 2010, with authority regarding his Wiggins and Batson claims. Wiggins is, I think, the failure to do an adequate mitigation investigation. On March 26, 2010, the court issued a memorandum in order on Williams' habeas claims. And basically, it found that the Missouri Supreme Court concluded that a Brady violation did not occur. If Williams wanted Colin Assaro's records, his discovery request should have been directed to the entities holding those records, not at the state. The rulings of the post-conviction court, the Missouri Supreme Court on this issue, are not contrary or an unreasonable application of clearly established federal law. The Missouri Supreme Court found as speculative and conclusory the allegation that prosecution's offer of assistance to 2 men who did not testify at trial is tantamount to the manufacture of evidence that negatively impacts the credibility of witnesses who testified and were subject to cross-examination. The court's ruling on this issue is not contrary to or an unreasonable application of clearly established federal law. And this is interesting. The claim about the attempted manufacture appears to be based on these people coming forward to Williams' counsel and saying the police or the prosecutor tried to get me to testify against you. But I don't ever find anywhere where the prosecution says, yeah, we thought they had information, so I'm kind of questioning the credibility of the people who claim that the state even tried to get them to testify.
Right.
Because when I read their affidavits, which were presented in 2003 in the post-conviction litigation, it's just really, kind kind of something just didn't it didn't pass the smell test.
Didn't from that. Yeah, makes sense.
As a claim 2 and 3, failure to impeach Cole and Asaro, he found the Missouri Supreme Court's ruling regarding the inadmissibility of testimony regarding Cole's prior bad acts is the highest authority on Missouri evidentiary law, and that the ruling was not the court's ruling on the admissibility in state court is barred from federal review in a federal habeas proceeding. He also found that the Williams failed to specify in his post-conviction motion any information in Cole's records that would have established that Cole was incompetent to testify, because he was alleging that Cole should have been, his attorney should have had him ruled incompetent to testify because he had a mental health history. The court stated that Williams' allegations about Cole's competence were speculative conclusions, not facts, which the post-conviction court properly dismissed. He also found that Williams did not receive ineffective assistance of counsel based on trial counsel's failure to investigate and present available evidence to impeach Cole and Asaro, and that was not an unreasonable determination of the facts, an unreasonable interpretation of the record, or an unreasonable application of established Supreme Court precedent. Regarding the perjured testimony actual innocence claim, he found that the claim is very distinct from the Brady claims, which attempted to undermine the credibility of Cole and Asaro's testimony, but did not accuse them of perjury. Because Williams has failed to show cause why he did not raise this claim in state court proceedings, the claim is procedurally defaulted. He also agreed with the state position that the record demonstrates that Williams' counsel effectively cross-examined both Cole and Asaro, and that contradictions in their testimony do not prove perjury, much less the prosecutor's knowing reliance on perjury. And then he found none of Williams's 5 unresolved issues constitute newly discovered evidence in the actual innocence context, because all these points could have been discovered earlier through the exercise of due diligence. He rejected the Batson claims, and I'm not going to go into that. It just basically that the prosecutor's reasons for challenging those jurors was not racially motivated, essentially. So the Missouri Supreme Court did not, unreasonably apply federal law or Supreme Court precedent to the issue and its findings. Now, this is on the Wiggins mitigating evidence claim. He found the state court's reliance on trial counsel's residual doubt strategy is contrary to the Supreme Court's decision in Wiggins. Trial strategy cannot excuse defense counsel's failure to perform a thorough investigation of a defendant's background in the death penalty case. The state court's decision rested solely on trial counsel's failure to put on mitigating evidence of Williams' background at the penalty phase, because counsel was relying on residual doubt instead. The state courts never addressed trial counsel's failure to conduct a thorough background investigation in their decisions. The state courts also determined that if Williams offered an abusive childhood defense, it would have been inconsistent with his residual doubt strategy. Williams offered substantial amounts of mitigating evidence to the post-conviction court, unlike the defendant in Williams versus Norris. This is an unreasonable determination of the facts in light of the evidence presented in state court proceedings. Even if Williams' background evidence was considered by trial counsel and strategically not offered as evidence, Williams would still be entitled to relief. So essentially, he granted relief on the mitigating evidence claim. He denied claims 7 and 10, and claim 8, the conflict of interest, because Williams had failed to establish in the post-conviction proceedings that a conflict of interest actually affected the adequacy of counsel's performance. He also rejected the claim number 11, 12, and 13 regarding the prosecutor's closing argument, the eliminating instruction regarding the escape attempt, and the duplicative aggravating circumstances. So it's hereby ordered that petitioner Marcellus Williams' petition for writ of habeas corpus is granted in part and denied in part. Williams' claims for relief as to his underlying condition is denied, or that should be conviction. Sorry. um, Williams' claim for relief from the penalty phase of his trial is granted based on trial counsel's constitutionally ineffective assistance for failing to investigate and present mitigating evidence of Williams' social and family history. It is further ordered that this case is remanded to the Circuit Court of the County of St. Louis, State of Missouri, for a new hearing of the penalty phase of Williams' trial. Separate judgment in accordance with this memorandum and order is entered the same date, and that was also entered. The state filed a motion to alter judgment on April 20th, 2010, which was ultimately denied. I'm not going to go into the arguments. Williams filed an opposition on May 11th, 2010, and the state filed a reply, basically because Williams said its positions were inconsistent, and they said, no, it's not. Memorandum and order was entered on June 16th, 2010, denying the motion to alter or amend. The state filed a notice of appeal. Williams filed a notice of cross appeal. Those were on the 12th and 13th of July. Williams for motion for certificate of appealability this went to the 8th Circuit Court of Appeal. The district court denied the motion for certificate of appealability on July 26, 2010. This went to the 8th Circuit Court of Appeals in dockets number 10-2579, which was the state appeal, and 10-2682, which was Williams' appeal. And those were eventually briefly consolidated and by the court. Williams' application for certificate of appealability was filed on August 16, 2010. The state opposed that on October 28, 2010, and Williams filed a reply. On December 14, 2010, a judgment was issued in both cases, which was denying the certificate of appealability and then dismissing the cases. A second order was issued the same day, vacating that judgment and reopening both appeals. And then a judgment was filed on December 15, 2010 in Williams' appeal, denying the application for certificate of appealability and dismissing that appeal. So then the only thing left would be the state appeal. Williams did file a petition for rehearing en banc on January 12, 2011. That was denied on February 23rd, 2011. He filed an application for extension of time to the U.S. Supreme Court, which was granted on May 3rd, 2011. He filed his petition for writ of certiorari on June 22nd, 2011. That was denied on November 11th, 2011. Oral argument in the state's appeal was held. They did their briefing, and I didn't go through all that. That was held on December 13th, 2011. On September 18th, 2012, the 5th Circuit Court of Appeal issued its opinion and found that the ineffective assistance claim was adjudicated on the merits. The district court failed to apply deference under 2254 when considering whether Williams had established prejudice from the alleged deficient performance of trial counsel. The district court proceeded as though the claim was subject to de novo review under Strickland, holding that the proffered evidence, if presented at trial, would establish a reasonable probability that the outcome of the penalty phase would have been different. This was error. The proper question before the federal court under EDPA is whether the decision of the Supreme Court of Missouri on the question of prejudice was contrary to or an unreasonable application of clearly established federal law. If the state court's determination passes muster under this standard, then Williams is not entitled to relief. And then they went on and they ultimately found that the state court reasonably could have questioned the weight of Williams's proposed mitigating evidence. First, any testimony from Williams would be susceptible to impeachment. In a deposition during state post-conviction review, Williams acknowledged that he lied under oath in 1987 in order to secure a favorable plea agreement. When asked if he would lie under oath when it suits him, he responded, "I mean, you should know better than me."
Wait, you
Sec-
mean he's not honest? Wait, he's not an upstanding
I know you're
citizen who
shocked. Do you,
always tells the truth? Like what?
do
Oh,
you
you
need
gotta stop the podcast. I'm gonna think.
do
Like
you
I
need
cannot
help
believe
climb?
it.
Do you need help climbing back onto your chair?
Yeah, I literally just fell down and broke my arm because I cannot believe he is not like an honest, upstanding member of society. This is amazing. I'm
Uh,
shocked.
they went on to say, second, any testimony by Dr. Cross about his diagnosis of Williams could have opened the door to additional aggravating evidence, such as Williams' prison disciplinary record. He committed more than 100 violations while incarcerated, including verbal and physical altercations with inmates and corrections officers, or rebuttal from a state expert to refute the Cross diagnoses. The undiscovered evidence also could act as a double edged sword, as the jurors could have concluded that Williams was simply beyond rehabilitation and a threat of future dangerousness because of his background in mental illnesses.
Wait, you mean after like what was this his like 20th conviction? He's not. He's gonna suddenly be rehabilitated? What do you? It was like his 20th something conviction.
Probably, yeah. We're up there because I think he had 16
Well, it's
adult.
just like the. It's just like the guy in North
Well,
Carolina.
actually, no, the Burger King and donut robberies were among the 16 adult convictions.
Well, I mean, this is the thing. It's like it's just I don't
This is
understand.
17.
As an aside, it's just like the guy that in the hate crime killed the poor lady on the bus in Charlotte, North Carolina. They suddenly, after like his 20th conviction, declared him mentally unfit for trial. I'm like,
Well,
I'm sorry, did you not notice the other 19 people that he'd attacked? Like,
well,
it's just,
actually, I think that is something a little bit different. He had 19 arrests and he had always been let go and they dropped charges
yeah,
and things like that. I don't know that he has that extensive of a conviction history. Being arrested is not being convicted.
well, fair.
And
Yeah,
what happened with Irina, and her name escapes me right now, Zarutska,
yeah, that's
um,
right.
was that he had been arrested for he attacked her on the train, and as he's walking out the train, he's like boasting, "I got a white girl."
Yeah,
But he has being found to be incompetent to stand trial on that charge has nothing to do with his criminal history.
no,
It's not
fair.
like something should have been found before and he should have been locked up before. That is right now his attorneys, and this may all be just part of a but I think what happens is when you're found incompetent, you go to a hospital, you're evaluated by the state, and then when they say you're competent, you go back and you're tried.
Right.
So I haven't looked into that. I read about that or heard about that recently. But that just means the trial can't go forward right now because he's not competent.
Yeah, but they'll probably let him out, and he'll be free. So
Well, I don't think so because
I know I'm just a little bit cynical. I mean,
I know.
the
I
two
know.
standards, basically the African American justice standard and the non-African American justice system, standard is starting to get a little cynical.
And I think part of the problem is you're getting progressive DAs who don't want to charge people and
If
progressive
they're
judges
if
who
they're
don't
black,
want to
they'll charge them if they're white, but
hold
like the
them in
Daniel
jail.
Penny trial in New York, that guy. There was an African American guy that literally
Yeah.
did the same crime like a few months earlier, and he did not even get tried. But the white guy, of course, gets tried.
Yeah. Well, that was a little different too because Daniel
But
Penny, you're talking about or Matthew Penny or Daniel Penny.
yeah, the guy on the subway who prevented, who that
Right.
the
Right.
mentally ill lunatic was the mentally ill African American guy was attacking subway riders, and he stopped him.
Yeah. Yeah. He did.
He went
And
on trial, but an African American guy had done the same thing, attacked like a white guy on the subway like a few months earlier, and didn't even get charged. But I digress.
I yeah, I think I, in a way I'm glad they charged Daniel Penny because he went through the process and he was acquitted. Um you could there was an argument that his action went too far and resulted in the death of the person he was subduing. Um, and I know it was a horrible. I know it was a horrible experience for him, but at least now he's been acquitted.
Well, yeah, and I'm not even speaking on the merits of the case, just the double standards of justice based on your skin color is
Yeah,
what's starting to
it
get frustrating.
yeah, and it can very well be, but sometimes it's comparing apples to oranges.
Yeah, no, sure.
I don't know the facts of the other case that you're referencing, where I mean it's wrong if the African because Daniel Penny was very specific. This person was acting up. Penny took steps to subdue the guy, and during the course of that, led to the person died based on the chokehold that Penny was using. And granted, Penny was doing what he thought needed to be done. But what were the facts? Even when you're trying to draw a racial equivalency, what are the facts of the other case? Are they really apples to apples, or are you comparing an apple to an orange?
No, absolutely. Makes
So
sense.
I I don't. I mean, I know sometimes, but sometimes they're not charging anybody with anything, and the judges are not holding anybody for anything. They're letting them go, and it doesn't matter what race they are, and it doesn't matter what crime they committed. I mean, people who have committed serious assault and caused serious injury are not being held. They're being let go on no cash bail, even though they've shown time and time again that they have a propensity to hurt innocent people that don't do anything to them for no reason.
Yeah.
So, anyway, so back to
Yeah. Apologies for the digression.
we digressed, but we're back. Um, the Supreme Court of Missouri ruled that Williams did not establish prejudice resulting from allegedly deficient performance by trial counsel. For the foregoing reasons, we conclude that the state court's decision was neither contrary to nor an unreasonable application of clearly established federal law. The district court did not consider the prejudice question through the deferential lens of EDPA. and this was reversible error. The judgment is reversed and the case is remanded with directions to dismiss the petition for writ of habeas corpus and to enter judgment for the respondent. Uh, Judge Malloy filed a dissent disagreeing with the majority's articulation of the EDPA standard to evaluate the question of prejudice related to counsel's failure to investigate and present mitigating evidence about Williams' troubled background. The majority concludes that it would have been reasonable for a state court to determine that the mitigating evidence was outweighed by the aggravating factors of Williams' crime. However, that is not what state court determined. The state court decided that the mitigating evidence would have been inconsistent with the theory counsel actually presented at sentencing. The state court thus concluded that Williams was not prejudiced by counsel's failure to present the evidence because the evidence was inconsistent with counsel's penalty phase strategy, even though the strategy was not adopted after a constitutionally sufficient investigation into Williams' background. The state court's prejudice determination is, in this respect, both an unreasonable application of Strickland and based on an unreasonable determination of the facts. The state court's judgment cannot survive 2254D analysis simply because, as the majority concludes, a reasonable state court might have determined for a different reason that Williams was not prejudiced. Furthermore, the cases cited by the majority do not support such a broad proposition. And then he went on to just argue against the majority's finding. A corrected opinion was issued on September 21st. They changed a couple of things, but mostly adding the word on following the word premised in page 18, second paragraph. A petition for rehearing was filed by Williams on October 31st, 2012. That was denied on December 6, 2012. And that denied the rehearing en banc and rehearing by the panel. And Judge Benton did not participate in the consideration or decision in this matter. He may have been a former Missouri State Supreme Court judge. It didn't really make it clear why he didn't participate. The mandate issued on December 13, 2012. Judgment was entered on December 19, 2012. By the district court. The matter is before the court after remand from the United States Court of Appeals for the Eighth Circuit, and in accordance with the Court of Appeals decision, it is hereby ordered, adjudged, and decreed that the petition of Marcellus Williams for a writ of habeas corpus pursuant to 28 U.S.C. 2254 is dismissed, and judgment is entered in favor of respondent Donald Roper. Williams filed a request for extension of time at the U.S. Supreme Court under 12A 807, which was granted on February 13, 2013. He filed a second request for EOT, which was granted on March 26, 2013. He filed his petition for a writ of certiorari under docket number 12-10141 on May 2nd, 2013. And that petition was denied on October 7th, 2013. So now this case goes back to the state court, and it goes to the Supreme Court of Missouri in case number SC 83934. So in Missouri, the Missouri Supreme Court sets the execution dates. And the case is in the docket number for the direct appeal. The counsel were Kent E. Gibson, Lawrence E. Comp. Those are counsel for William. The state was represented by Jeremiah Nixon, Evan Buchheim, Michael J. Spillane, and Andrew J. Clark. And, they each appeared at different points. Motion to execution date was filed by the state on March 17, 2014. Suggestions in opposition were filed by Williams on March 28, 2014. Unfortunately, these pleadings are not available, so I don't know what his opposition was. Reply suggestions in support of setting execution date were filed on April 1st, 2014, and an order and warrant of execution were issued on December 17th, 2014, scheduling Williams's execution for January 28th, 2015. Williams then files a subsequent state claim in the Supreme Court of Missouri under docket number SC 94720. Again, Gibson and Comp represent him. Michael J. Spillane represented the state. He filed a petition for writ of habeas corpus on January 9th, 2015, arguing that he is being deprived. In Claim 1, petitioner is being deprived of his 6th and 14th Amendment rights to compulsory process and due process of law because existing Missouri law, including post-conviction DNA testing statute, precludes him from obtaining access to exculpatory evidence and further DNA analysis necessary to allow him a fair opportunity to prove his innocence of the murder of Felicia Gale. And then under Claim 2, petitioner's continued incarceration and upcoming execution for the offense of first-degree murder violates the 8th and 14th Amendments and Article 1, Section 10 of the Missouri Constitution because the existing evidence likely to emerge if further discovery is ordered and future DNA tests are conducted establishes he is innocent of the murder of Felicia Gale. So he makes a gateway innocence, freestanding actual innocence, claims. He cites to evidence developed in state post-conviction, which undermines the state case, which is basically the impeachment evidence of Colin Asaro that's been rejected in prior proceedings. And then he argues that there is sufficient evidence of petitioner's innocence to require his death sentence to be commuted to life imprisonment under Omreen and Missouri's proportionality review statute. He filed a motion to stay his execution on January 9th, 2015. The state opposed that on January 15th, 2015. I said 2019, it should be 2015. I need to go up from 1.5 to 2.0 on my readers. And on January 22nd, 2015, the state Supreme Court issued an order sustaining the motion for stay of execution pending disposition of the writ of habeas corpus, vacating the warrant of execution, and overruling Williams' motion to vacate the warrant of execution as moot. Then he filed he also filed a civil rights challenge, 42 U.S.C. 1983 challenge in the U.S. District Court for Eastern District of Missouri. That was under docket number 4:15-CV0070 RWS. He was represented by Lawrence E. Comp, who was with the Federal Public Defender's Office, and Kent E. Gibson. The state was represented by Michael Spillane. He filed his complaint on January 12th, 2015, citing evidence to be tested, which was fingernail clippings from Lisha, the knife, which was the murder weapon. He wanted hairs removed from Lisha's body, examined for biological material, and submission of any available biological material for STR testing, and an examination of the hairs and pubic hairs recovered from the rug under Lisha's body for biological material and submission of any available biological material for STR testing. He alleged violation of due process, meaningful access to the courts, actual innocence and cruel and unusual punishment, compulsory process and clemency due process, and requested that the status quo be preserved by issuing a stay of execution, because this was, I think, before his execution was stayed in state court. An order granting a temporary restraining order and preliminary injunction barring destruction, testing, removal, alteration, or contamination of evidence that Williams seeks to test or seeks to access, to issue an order requiring defendant release the items to be tested for DNA testing, and to upload the upload of all CODIS eligible profiles into the CODIS database, to issue an order requiring the comparison of all developed profiles to any profiles developed in the investigation of the Pagedale murder, to grant reasonable attorney's fees pursuant to 47 U.S.C. 1988 and the laws of the United States, and to grant any other relief the court deems just and proper. Now, in reality, he can't. The federal court cannot order any of the state court to do any of this. So this is one of the reasons that
Do you think he knows that and he's just wasting time
I think
to
it.
clog the
Yeah, I think
courts?
it is. It obviously is generally a throw it at the wall and see if it sticks, or a shotgun approach, and we'll see this in part 3 as well, and it's even more egregious.
Right.
Um, but he also filed a motion for preliminary injunction and stay of execution in the federal court. And on January 14th, 2015, so this could have come before the prior state court, but
Right.
on January 14th, the federal court issued a memorandum in order finding Williams' due process claim is wholly conclusory and is unsupported by any federal case law. Williams admit that he failed to take advantage of Section 547.035 when he had the opportunity, both at trial and in his post-conviction proceedings, and he admits that his own failure is the reason he has no remedy under state law. Plaintiff was not deprived of an opportunity to be heard. He had the opportunity to raise the DNA claim at trial and in post-conviction proceedings, but failed to do so. As a result, plaintiff's due process claim fails to state a claim upon which relief can be granted. He also rejected the right of access to the court claim as wholly frivolous. Williams has 2 federally appointed attorneys who are being compensated to seek executive clemency and any stays of execution. Williams' attorneys in the instant case is one of those attorneys. Williams does not allege that he has been deprived of access to a law library or that prison officials have interfered with his ability to file papers in court or contact his attorneys. And as I said above, Williams does not have an established federal right to endlessly attack his conviction after his final and post-conviction proceedings are over. Cruel and unusual punishment. The court also found that claim is just a reiteration of previous claims. The claim is also legally frivolous, and Williams fails to cite any case law to support this claim or even to articulate the standard for Eighth Amendment violations. The state's refusal to conduct DNA testing is not punishment. Therefore, there is no Eighth Amendment violation. The compulsory process claim, the court found that it was conclusory and unsupported by case law, and that the claim has not even been articulated in a manner that makes legal sense. The Sixth Amendment applies to criminal prosecutions. Williams' conviction is final. As a result, this claim is also frivolous. And finally, the clemency due process claim was also found to be frivolous. Plaintiff has 2 lawyers seeking clemency on his behalf. Missouri's clemency process does not guarantee discovery of evidence used at trial. So the claim was dismissed by an order on January 14, 2015. And he found that the court also found that it was ordered that an appeal from this action would not be taken in good faith. And then we go back to the state court subsequent state claim with a writ of habeas corpus in the Missouri Supreme Court. On January 30th, 2015, the respondent was ordered to show cause on or before March 2nd, 2015, why a writ of habeas corpus should not issue, and petitioner shall file a detailed response to respondent's answer on or before March 23rd, 2015. The state did file an opposition on February 27, 2015. Williams' request for an extension of time was granted on March 20th. Williams filed a reply on April 2nd. And then on May 26, 2015, the Missouri Supreme Court issued an order uh, appointing the Honorable Gary Oxenhandler as a master of this court to ensure DNA testing of appropriate items at issue in this cause and to report to this court the results of each testing. In furtherance of this charge, the master may hold pretrial conferences, may take evidence on the issues, joined with full power and authority to issue subpoenas, compel production of books, papers, and documents, and the attendance of witnesses. May hear and determine all objections to testimony in the same manner and to the same extent as this court might in a trial before it, and shall arrange for the reporting and transcribing of the testimony. So the case went to a letter was also issued on June 1st with a PDF of all filings in the case at the Missouri Supreme Court level. The case then went to the Circuit Court of the County of Boone, because that's where Judge Oxenhandler is a judge.
Oh, I know right where that is. That's
Oh, you
Columbia.
do? Boone, Missouri.
Yeah,
Okay. Boone
that's
County.
Columbia, Missouri, Boone County, right in the middle of the state.
That's in the 15th Judicial Circuit. The docket number assigned was 15BA-CV01828 before the Honorable Gary Oxenhandler. Williams was still represented by Gibson and Comp, and the state was represented by Michael Spillane and Caroline M. Coulter.
I'm still thinking about Mickey Spillane, even though it's like an hour later.
Yeah, now I know. I'm sorry.
He was, I can't remember the show, but yeah, was he? I can't remember.
It was the one with Stacy Keach.
Yes, exactly. Yes, maybe.
And I can't remember the name now.
Yeah, it had like another name, but
yeah, I can't remember the name. Why don't you get on the little Google machine?
Yeah, there you go.
Get on the Google machine and give us an answer, Kyle.
Yeah, absolutely.
Your assignment, if you choose to accept it. And I know a lot of people out there are not going to get that reference unless they've watched the Tom Cruise movies. So a hearing or telephone conference was held on.
Okay. Sorry. Okay. Okay, now this all makes sense because that's what I was thinking. So Mickey Spillane was the author of the books about Mike Hammer, who was the detective. So Mickey Spillane, actually Frank Morrison Spillane, better known as Mickey, he was the author. But yes, he wrote the Mike Hammer novel series.
Okay, yeah, because there was a television series.
Yeah, it was in the 80s. Huge, had the fedora. Yep.
Okay. So, and it was the I remember noir, like in the 50s, those kind of detective novels became very popular.
Yeah.
So, okay.
I digress this again.
That's okay. That's all right. We're going to get back on track because we are close to finishing without having to bail. Yay! Okay, June 24th, 2015, Judge Oxenhandler held a hearing by telephone. It was on the record. The attorneys Spillane, Coulter, and Comp appeared. Jointly proposed testing protocol was filed this date, considered by the court, and approved, and the parties shall comply. Petitioner suggests PD has agreed to fund testing, which I think is public defender. Parties shall forthwith agree in writing as to inventory of items to be tested, which inventory shall be submitted to the court upon completion. Assuming submission of items for testing within 10 days, parties suggest samples should be ready for submission to CODIS within 8 weeks thereafter. Parties shall file status report no later than July 23rd, 2015, when cause taken under advisement, and clerk shall so notify court. Copy of this order shall be forthwith sent to the clerk of the Supreme Court. Another hearing was held on July 24th. Spillane, Comp, and Gibson appeared. After due consideration, all parties waived an evidentiary hearing. Bodie Thelmark Forensics hereby authorized to exhaust or consume biological materials in order to complete DNA testing. Another order was entered on March 21st, 2016. The parties filed a report suggesting further time was needed to complete analysis. However, parties filed no timeline for the completion of the analysis. Anticipated timeline shall be filed no later than March 28, 2016 at 9 a.m. And again, all this is being forwarded to the Supreme Court as they go. Um, on April 17, 2016, Williams filed a DNA report. And I'm going to go through when we start off next episode, part 3. I will go through the various DNA reports and the findings from those DNA reports. April 20th, 2016, the court issued an order, the court being in receipt of the Bodie Cellmark Forensic Case Report dated April 8, 2016, and filed by Petitioner Williams, and the suggestion of the state that said report is ripe for submission by the master to the Supreme Court. Upon acknowledgement by petitioner that petitioner agrees that the report is ripe for submission to the Supreme Court, the master will proceed accordingly. Petitioner shall file a written acknowledgement or other suggestion no later than May 2nd, 2016, noon, and shall provide a copy of the filing to Susan Tatters at courtsmissouri.gov for forwarding to the master. Another order was entered on May 11th, 2016, petitioner having filed a response on May 2nd, 2016, suggesting that submission of a master's report at this time would be premature and that additional testing is required, and no reply to the response having been filed. Testing shall continue as described in petitioner's response. Parties shall file status report no later than June 13th, 2016, and clerk shall then provide said report to the clerk of court, shall forthwith acknowledge receipt of this order to the court. And a CC of the order was sent to Bill Thompson, which I think may have been the clerk of the Supreme Court. On June 15th, 2016, upon reviewing parties' joint status update and noting that the DNA testing continues, parties shall file a status report no later than August 12th, 2016, 9 a.m. So what this is demonstrating is that Williams is getting a fair opportunity for his DNA testing. And anybody who claims that it wasn't fair is ignoring this. September 14th, 2016, the court, having reviewed the parties' respective status reports filed on September 6th, 2016 and September 8th, 2016, the parties shall forthwith schedule the deposition of the unnamed Bodie technician referenced in petitioner's report and immediately advise the court of the deposition date. Upon completion of the deposition, the same shall be filed with the court, and the parties shall immediately set a court hearing via S. Tatters to address the issues before the court. If no deposition date has been set within 7 days of this order, each party shall file a report as to why the same is not set. December 1st, 2016, the deposition of the Bodie technician having been completed, parties shall forthwith schedule a hearing via Susan Tatters, clerk, and Tatters shall report on status of setting within 5 days of this order. A hearing was held by telephone on December 7th, 2016. Attorneys Comp, Gibson, Coulter, and Spillane appear. Expert deposition being completed. Williams is given 21 days from this date to file a response to Steele's brief, and Steele's given 7 days thereafter to reply unless waived. Upon filing of Steele reply, a written waiver of same, clerk shall advise master, and master shall consider whether cause ripe for resubmission to the Supreme Court. At this time, and subject to the briefs to be filed, parties suggest no further hearings are required. In any event, the clerk shall advise the court of the pending of this cause no later than January 5th, 2017. An order was then issued on January 5th, 2017. On May 26, 2015, an order was entered by the Supreme Court in State ex rel. Marcellus Williams versus Troy Steele, being case number SC 94720, appointing Gary Oxenhandler as master of the court to ensure DNA testing of appropriate items and to report to the Supreme Court the results of such testing. In light of the case being assigned to a then Boone County judge, and for administrative tracking purposes, case SC 94720 was given a temporary case number 15BA CV01828. All actions taken by the master are reflected in case number 15BA CV01828. Over the course of the next 19 months, the master closely monitored the DNA testing suggested and agreed to by the parties. 5 telephone conferences were held. The parties filed numerous status and progress reports, and the master entered innumerable orders. Everything was on the record. DNA testing is now complete, and in turn, the work of the master is complete. The master respectfully suggests that the parties' final briefs in this matter, respondent's pre-hearing brief filed on December 6, 2016, petitioner's post-DNA testing brief filed on December 28, 2016, and respondent's reply brief filed December 30th, 2016, succinctly set forth the current arguments of the parties. The clerk shall forthwith file this order and provide a copy to Cynthia Turley, clerk of the Supreme Court. A notice of dismissal was entered on November 9th, 2017. So for 11 months, the Supreme Court reviewed all the briefs. This case will be dismissed. Oh, this was in, I'm sorry, my apologies. This was in Boone County. This was a clerk entered order of notice of dismissal. The case will be dismissed December 11, 2017 for failure to prosecute. Dismissal without prejudice is pursuant to Rule 37.1, Paragraph A of the 13th Judicial Circuit Court, which states all cases remaining inactive and on file for a period of 6 months shall, upon 30 days written notice to the parties or their attorneys, be dismissed without prejudice for failure to prosecute except for good cause shown. And so the case was dismissed in Boone County on December 13, 2017. The case then went back to the Supreme Court of Missouri. And again, attorneys were Gibson and Comp and Spillane. The notice of entry from Boone County was filed on March 24, 2016. The master's order of January 5th, 2017 was filed in the Supreme Court on January 5th, 2017. On January 31st, 2017, the Supreme Court issued its order on consideration of the petition for a writ of habeas corpus herein to the said respondent. It is ordered by the court here that the said petition be, and the same is hereby denied. And again, I believe that that initial DNA report could not exclude Williams from the DNA on the knife at that time. But again, I'll go into the details of those DNA reports at the beginning of the next part 3. The mandate also issued on January 31st, 2017. Williams filed a petition for writ of certiorari to the U.S. Supreme Court on April 27, 2017. The state opposed that. The docket number was 16-8963. A conference was held on July 22nd, 2017, and the petition was denied on June 26, 2017. The conference was June 22nd. So then on execution date number 2, it's actually like maybe 4, because he had an execution date set prior to his direct appeal that was stayed. He had an execution date set at the conclusion of his state post-conviction, but that was stayed. So this is actually like date number 4. Again, still Williams and Gibson and Comp and Spillane. The state filed a renewed motion to set execution date on February 6, 2017. Williams filed a suggestion opposition on March 15th, 2017. The order was entered per curiam by the court on April 26, 2017, scheduling Williams's execution for August 22nd, 2017. Williams filed a successive federal claim in the Eastern District of Missouri docket. It was in the same docket number as his original habeas 4:05 CV 01474 RWS, still before Judge Rodney W. Sipple. Attorneys were Kent Gibson and Lawrence Comp, who's the Capital Habeas Unit Chief Federal Public Defender, Western District of Missouri, and Michael J. Spillane. Williams filed a motion for relief from judgment of or order pursuant to Federal Rule of Civil Procedure 60B on July 31st, 2017. And he basically argued he had new DNA results which excluded him as the source of male DNA found on the murder weapon. The 60B motion only attacks a defect in the integrity of the federal habeas proceedings, and thus this court is not prevented from granting relief he seeks. He alleged extraordinary circumstances justify reopening the judgment pursuant to Rule 60B6 because of the new DNA results. And the nature of the new facts demonstrates that the discovery denial precluded a full and fair merits review, that he had significant actual innocence issue as to guilt and or penalty, that there was a greater need for reliability and fairness, and state's interests were not harmed. He also filed a motion to stay his execution on July 31st. A memorandum in order was issued on August 1st, 2017, requesting a response by August 8th, 2017 from respondent, and then granting and then ordering a reply brief to be filed no later than August 14th. The response was filed on August 2nd, 2017. Williams' reply brief was filed on August 11th, 2017. And a reply brief in support of his motion for relief was also filed on August 11th. On August 15th, 2017, the court filed an order denied Williams' motion because he fails to establish grounds for relief under Rule 60B6. The claim of actual innocence related to the new DNA testing related to Claim 4 is not a ground for habeas relief, and Williams' motion is really a successive habeas petition, which I cannot entertain absent permission from the United States Court of Appeals for the Eighth Circuit. He went on to say, first, Williams' newly discovered evidence does not meet the standard of Rule 60B2. The DNA evidence on the knife handle is not new evidence, which could not have been discovered in time to move for a new trial. Williams conducted discovery of fingernail and hair samples before trial. He does not offer any reason that he was prevented from conducting DNA testing on the knife handle. Williams' request for DNA discovery on August 29, 2006 never mentioned testing of the knife handle. As a result, I did not err in denying Williams' request for DNA discovery because he never sought discovery regarding the knife handle. And he was seeking discovery of hairs and biological materials from those hairs. Second, Williams' evidence about the knife handle is not an extraordinary circumstances under Rule 60B6. The knife handle evidence is equivocal based on the conflicting opinions of Williams' experts who examined the DNA data. Moreover, Williams was convicted on other evidence, including witness testimony, possession of the victim's property, and Williams' sale of the victim's laptop. Third, any evidentiary issues regarding DNA evidence have no impact on Williams' claim of actual innocence. As I stated in my order denying Williams ground for relief based on actual innocence, and as I restated here, a claim of actual innocence is not a cognizable ground for relief for federal habeas relief. As a result, Williams' motion for Rule 60B6 relief regarding DNA testing and newly discovered DNA evidence is futile and will be denied. He also denied the motion on the alternative ground that it is a successive habeas petition. So a notice of appeal was filed on August 16, 2017. The case went to the Eighth Circuit Court of Appeal under docket number 17-2801. Williams also filed a motion for stay of execution on August 17th and an application for certificate of appealability on August 17th. The state filed its opposition on August 17th. Williams also filed a reply on August 18th, 2017. The judgment was filed by the Eighth Circuit. The application for certificate of appealability filed by Williams has been considered by the court and is denied. We conclude that jurists of reason could not disagree with the district court's resolution of the motion for relief from judgment, or conclude that the issues presented are adequate to deserve encouragement to proceed further. In our view, the first two independent grounds for the district court's decision are not debatable. Even assuming for the sake of analysis that the third ground must be considered, it is not reasonably debatable that Williams could not meet the extraordinarily high threshold that would apply to any freestanding claim of actual innocence that might be recognized. See Herrera versus Collins. The motion for stay of execution is also denied. He filed a request for extension of a stay of execution at the U.S. Supreme Court under docket number 17A201 on August 20th. He filed a petition for writ of certiorari on the same date under docket number 175642. A brief in opposition was filed by the state on August 20th. A reply brief was filed by Williams on the 21st. Conference was held on September 24th, 2017. And on October 2nd, 2017, the petition was denied. However, in subsequent state claim was filed in the Supreme Court of Missouri, kind of at the same time again. It gets very confusing with these because we're going back and forth in time. We're going to get time sickness. Kent E. Gibson was the attorney for Williams. Michael Spillane was the attorney for the state. A petition for writ of habeas corpus was filed again on August 14, 2017, under docket number 96625, SC 96625. Williams also filed a motion for stay of execution. The petition for writ of habeas corpus and motion for stay were the petition for writ of habeas corpus was denied, and the motion for stay was overruled on August 15th, 2017, and the mandate issued on the same date. Williams filed a application for stay of execution under 17A198 on August 18th, 2017, from the state court habeas denial. He also filed a petition for writ of habeas corpus on August 18th under docket number 175641. That was opposed by the state on August 19th. Williams filed a reply brief on August 21st. The case was conferenced on September 25th, 2017, and an order denying the petition was also entered on October 2nd, 2017. Also, in August of 2017, the Midwest Innocence Project, which is now involved, and the Innocence Project, which became involved with Williams's case, filed a request to appoint an independent board of inquiry pursuant to Section 552070 for Williams's case. Governor Eric R. Greitens on August 22nd, 2017, issued executive order number 17-20. And he basically, by virtue of the authority vested in me by the Constitution and laws of the state of Missouri, hereby invoke the provisions of Section 552.070, revised statutes of Missouri, and establish a board of inquiry in the matter of Marcellus Williams, an inmate condemned to death, and hereby order a stay of execution for Williams until such time as the governor makes a final determination as to whether or not he should be granted clemency. So he basically created a board to examine of 5 members appointed by the governor to examine Williams's case and to recommend whether Williams should be granted clemency. That board was appointed on September 12, 2017. The execution was stayed. Uh, the the board was Judge Booker Shaw, Judge Michael David, Judge Peggy McGraw Fenner, Judge Carol Jackson, and Judge Paul Spinden. And then on June 1st, 2018, Greitens stepped down as governor of Missouri. In February, he was charged with felony invasion of privacy related to an extramarital relationship. Prosecutors alleged that he had taken an unauthorized photograph of the woman involved. The woman also made allegations that he had sexually assaulted her, which Greitens denied. A bipartisan special investigating committee of the Missouri House of Representatives reviewed the matter and released a report in April of 2018. In that report, Greitens was separately indicted in April of 2018. After that report, Greitens was separately indicted on a felony count of computer tampering. The charge concerned the alleged use of a donor list from the Mission Continues, the nonprofit organization he co-founded, for political fundraising without their permission. All criminal charges in both cases were dropped in May of 2018. Greitens resigned from the governorship on June 1st, 2018, shortly after the Missouri General Assembly convened a special session to consider possible impeachment proceedings. On June 1st, Lieutenant Governor Michael L. Parsons was sworn in as governor after Greitens' resignation. On November 3rd, 2020, Governor Parsons defeated State Auditor Nicole Galloway in the general election. And on June 29, 2023, Governor Parsons issued Executive Order 23-06. And he basically, by virtue of the authority vested in me by the Constitution and the laws of the state of Missouri, specifically Article 4, Section 7 of the Constitution of the state of Missouri, and Section 552.070 Missouri Revised Statutes of Missouri, do hereby rescind Executive Order 17-20, thereby dissolving the Board of Inquiry established therein. With this executive order, I remove any legal impediments to the lawful execution of Marcellus Williams created by Executive Order 17-20, including the order staying the execution. And so that was entered on June 29th, 2023. The Board of Inquiry had not done anything or issued any report, or, there's no, the proceedings are confidential, so, and the report would be confidential. So, but nothing had been done by the Board of Inquiry in all that time. So, Governor, we're gonna stop at the dissolution of 17-20 and Board of Inquiry.
Got it. Thank you. A lot of information.
So, yeah, that's why I decided. And the next the next episode, part 3, is going to deal solely with events in 2024 leading up to Williams's execution. Gotcha. But it's a lot, and it was complicated, and it jumps back and forth, and so I didn't want to try to have to rush through it, and it would have made this episode way too long.
All right.
Because I was about halfway through, and I was at 79 pages.
Holy smokes.
Mm-hmm. With what I did in episode 2. So, and I'm just writing little notes, and I don't know if anybody can hear poor Remy snoring his little head off. He was abandoned today for French Quarter Fest.
What's French Quarter Fest?
It is, this is festival season in Louisiana. We had the Strawberry Festival last weekend. We've got French Quarter Fest this weekend. We'll have Jazz and Heritage Festival in next 2 weeks. So we just have festival season. It's French Quarter Fest. They have bands play, and it's kind
Right.
of a mini jazz fest in the French Quarter.
Nice.
And it seems like it's grown every year.
Yeah, Mrs. Kyle and my son and his best friend were there a week ago, I think.
Yeah, I saw that.
Yeah, they had a fun, crazy New Orleans time.
Mhm. Yeah. I was wondering if you were with him.
No, I had to work, but
Oh.
they had the day off and had a great time.
Well, great. I'm glad they did. I saw some of the posts on Facebook,
Nice.
but and I like the posts. So tell your wife that if she sees me liking a post and they're here, feel free to contact me.
Yeah, I'll do that. I honestly, I didn't even think about it. I don't know. I guess it's being a man thing. I always forget those things. Never remember. It's like comes with being a dude.
Yeah. So yeah, no, whenever your wife or your daughter or your son, if y'all are in town, feel free to call me. I'd love to, meet up with you in real life.
Yeah, that'd be great.
So, all right. Well, I think that's all we have for today. Um, do you have any closing thoughts on so far,
I
other
mean,
than
not
your
really.
shock at Williams's dishonesty?
I mean, it's just, I mean, I don't know. I make these same comments all the time. I mean, I appreciate it. I don't want anyone falsely convicted, all that jazz, but I just, the amount of time and money and resources that we spend just on the obviously guilty, it's just like, I'm not saying you get convicted and then you take you out to the courthouse and shoot you the next day, but feels like there's the balance. I mean, just letting these guys who were so clearly guilty just clog up the courts with crap. It's just such a waste of time and resources. It's frustrating. And this guy's like obviously guilty, right? Like
Yeah.
he could not be more obviously guilty than this dude. And it's just like the fact that we have to spend, millions of dollars, going through all this bullshit is just a little frustrating.
Yeah. I agree. I really agree. And um, I mean, with like Rodney Reed, he's filed yet another claim, and his
Okay, I take that back. Rodney Reed is probably more obviously
Rodney
guilty
Reed
than
is
this
more
guy.
egregious because the DNA
Uh,
evidence is
yeah, it's like,
significant and conclusive.
right. It's just, I mean, it's a balance, right? Because you
Mhm.
want to have a just justice system and you want to enable those folks to make sure justice is carried out. But like, it gets a little bit ridiculous.
Right.
I don't know. We need to figure out a better system.
Yeah. All right. Well, we'll end it there. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter, O'Brien L. Ann. And you can also follow me on Spotify as one of my coworkers, Amy. Thank you for the follow. Um, Kyle and I will return in 2 weeks for episode 7, State of Missouri versus Marcellus Williams, part 3. We'll wrap up our review of the case against Williams and talk about the 2024 efforts of the St. Louis County Prosecutor's Office to vacate Williams' murder conviction and the office's opposition to his execution on September 24th, 2025, including the DNA results that were falsely held out to exclude Williams as the perpetrator of Felicia's murder. Until then, have a great 2 weeks and stay safe.